Hey everyone, welcome to Legalbytes. I'm Alyte, and on this channel we explain the law one bite at a time. Last week, a federal district court in the Western District of Pennsylvania struck down the state's pandemic lockdown laws, and we're going to go over the whole shebang. Coming on up on Legalbytes. Okay, so before we get into it, because there is a lot to go over, and as you've probably noticed from the title of this video, this subject is getting split in two. In this video, we'll be going over the background and the foundational stuff that the court went through in order to reach the conclusions it did. In the next video, we'll go through the actual merits of the case. If you're watching this video right after its upload, we'll be trying to get these two videos out within a couple days of each other so we don't leave you hanging for too long. Okay, moving forward. The first thing to note about this opinion is that it comes from a federal district court, which means it actually doesn't have an immediate effect on most of the people in the country. To make sure we're all on the same page here, in the United States, most lawsuits are filed either in state court or federal court. And by the way, if you know this stuff, feel free to skip ahead. I've got chapter designations and timestamps in the description below. Okay, in determining where a case should be filed, think of the default as state court. Any general garden variety lawsuit governing breaches of contract, medical malpractice, automobile collision, personal injury cases, employment litigation, wills and trust litigation, those are all going to be generally state law claims, so those lawsuits get filed in state court. Now, there are two main ways to get your lawsuit into federal court if that's what you want.
If that's what you're into.
Diversity jurisdiction or subject matter jurisdiction. Diversity jurisdiction is where the plaintiff and the defendant live in two different states or where one of them lives outside the United States altogether. Subject matter jurisdiction is where a central question of the lawsuit has to do with federal law, for example, a violation of the Constitution or a violation of a federal statute. Either way, in both federal and state judicial pipelines, you generally have a certain hierarchy of courts. The lowest level is the district or the superior court level. If one party is unhappy with the result of their case, they can appeal to the second level, which is the appellate level. And then, if they want to keep fighting after that, they can appeal to the state Supreme Court or the United States Supreme Court, whatever the circumstances may be. There are some exceptions to this ordering, depending on the state, and there are ways for a party to try to request emergency relief from the United States Supreme Court directly. But basically, this is the general procedure setup that cases might see. Looking at this case, although the legal issues are about state executive orders, because the claims are all made under various parts of the United States Constitution, it is properly in federal court. Also, it's important to note that this opinion, while very important, affects only the lockdown laws in Pennsylvania, and particularly the ones that are before the judge in this case, the Honorable William S. Stickman IV. If you're looking at this headline in Arizona, for example, for you, this is persuasive authority, meaning it doesn't really affect you directly. When I say persuasive authority, I'm talking about one of two types of opinions: binding authority and persuasive authority. Binding authority means a court opinion that sets forth rules which the courts have to follow. Persuasive means that courts can use the opinion but aren't required to follow it. To put this in concrete terms, lower court opinions are generally considered persuasive authority. Appellate court opinions, on the other hand, are binding upon the lower courts that fall under the umbrella of that appellate court. So, for example, everyone has to follow United States Supreme Court decisions. Those decisions are binding everywhere in the United States. And federal district courts in California have to follow the Ninth Circuit court opinions. But courts falling in different circuits, let's say Texas federal courts, for example, which are in the Fifth Circuit, they don't have to follow Ninth Circuit appellate decisions because they're in a totally different circuit. A party to a lawsuit can still try to use case law from other jurisdictions as persuasive authority, but the court does not have to consider it.
She doesn't even go here.
Do you even go to this school?
No, I just have a lot of feelings.
Okay, go home.
Applying all of that to this situation, all of that is to say that if you live outside Pennsylvania, this particular opinion is something that might get applied to cases brought before judges in your jurisdiction, but also might not. In other words, it's an important case to know about, but don't go around thinking that this means that all lockdowns everywhere have now been struck down. Also, while it is significant in that the court decided that the lockdown laws are unconstitutional, we already know that the state of Pennsylvania plans to appeal the decision, and it could very well end up at the Supreme Court level. That said, it is significant because it tries to make sense of a tough conundrum that asks, where do civil liberties stand during a public health emergency? To break the whole case down, first we'll go through the basics of the case. In other words, who's suing whom and why. Then we'll work through the way that this court decided to set up the constitutional analysis framework, which is a key issue you'll want to understand in order to be fully educated on this issue. Then we'll go over the merits of the case, and I'll give a conclusion. In this video, we'll go over the first two, and in the next video, we'll go over number 3 and number 4. Okay, let's get into it. Okay, so this case was actually brought by a number of plaintiffs, which the court places into 3 groups. First is the county plaintiffs, which consists of Butler, Fayette, Greene, and Washington counties in Pennsylvania. Second is the political plaintiffs, which consists of U.S. Congressmember Mike Kelly and Pennsylvania state Congress members Darrell Metcalfe, Macy Mostello, and Tim Bonner. The final group is the business plaintiffs, which consists of a number of sole proprietors and small business owners in Pennsylvania. They brought the case against Pennsylvania Governor Thomas Wolfe and Pennsylvania Secretary of Health Rachel Levine for measures they took to combat the spread of the novel coronavirus. What the plaintiffs were asking the court to do was to issue a declaration that the defendants' actions violated the United States Constitution. Particularly, there are 2 types of orders that were before the court. The first was a July 15, 2020 order prohibiting indoor events and gatherings of more than 25 people, as well as outdoor events and gatherings of more than 250 people. The second kind was orders closing, quote, non-life sustaining, unquote, businesses and directing Pennsylvanians to stay home. The plaintiffs in the case made 3 arguments. The first was that the June 15th order violated people's First Amendment right to assemble. The second was that the stay-at-home and business closure orders violated the 14th Amendment's due process clause. The third argument was that the business closure orders violate the 14th Amendment's equal protection clause. Now, it's important to note that the plaintiffs in this case were only challenging the business closure provisions that distinguished between life-sustaining and non-life-sustaining businesses. There was more to that order which was not part of the lawsuit, and it therefore remains standing regardless of the outcome of this lawsuit. Okay, moving on. So in order to properly hear a case like this, the court has to first determine what level of scrutiny that needs to be applied to the various constitutional claims in the case. Now, when I say courts apply a certain level of scrutiny, I'm referring to a particular way that courts approach constitutional issues. Think of it like the regulation is a high jumper. If the regulation wants to survive a court's ruling, it needs to clear the bar wherever it's set. The scrutiny question determines where the courts set that bar. Over the years, the Supreme Court has developed a 3-tier scrutiny system, and it's based on the fact that there are different types of constitutional issues, some of which stack up as heavier or more important than others. For example, claims for the deprivation of property are generally considered less important than other constitutional claims. On the other hand, if as a plaintiff you make a good First Amendment religious claim, you have a pretty strong likelihood of winning. So because courts have kind of a hierarchy of rights, they apply different levels of scrutiny depending on the constitutional issue. The highest level of scrutiny, meaning the most difficult standard for the regulation to meet, is strict scrutiny. This is used for core constitutional rights like regulations of political speech, discrimination on the basis of race, discrimination on the basis of religion, the right to vote, and in some circumstances, the right to travel. To meet the strict scrutiny standard, the regulation in question must be motivated by a compelling government interest, and it must be narrowly tailored to serve that government interest. Basically, it needs to be the case that what the government is doing is really, really important, and the way that the regulation goes about it is pretty much the only way to do it. If, on the other hand, the interest isn't compelling, or there are less restrictive alternatives for how to meet that compelling interest, the court will strike down that regulation as unconstitutional. The second highest level of scrutiny is intermediate scrutiny. Some courts will refer to intermediate scrutiny as heightened scrutiny. That's usually used for cases like discrimination on the basis of sex, discrimination on the basis of being born out of wedlock, or free speech cases where the regulation in question is content neutral. When I say content neutral, I mean where the law doesn't make a difference on what you say, but rather where you say it, when you say it, or how you say it. An example of a content neutral speech regulation is where a city requires you to get a permit from the city prior to scheduling a march or demonstration. Other areas that have also gotten the intermediate scrutiny treatment include laws regulating mass media, adult entertainment, and highway signs. In order to pass muster under intermediate scrutiny, the law in question must further an important government interest and must do so by means that are substantially related to that interest. So note the comparison there, that where strict scrutiny needs to tie regulation to a compelling interest, intermediate scrutiny only needs to be an important government interest. And then where strict scrutiny needs to be narrowly tailored to the interest, intermediate scrutiny only needs to be substantially related to the interest. But That said, plenty of regulations have been struck down by the courts because the regulation either wasn't put out for an important interest or because there was too much of a disconnect between the effect of the regulation and an alleged important interest. Finally, we have the third tier, which is the lowest tier, and by far the easiest for the government to meet, the rational basis test or rational review. This is basically used in all other constitutional cases where there's no issue affecting a protected class and there's no core fundamental rights at issue. Examples include cases that involve laws concerning property, like regulations over interstate commerce. In order to pass rational review, the law in question must have a legitimate government interest and there must be a rational connection between the regulation's goals and the means that the regulation takes to meet those goals. But wait, there's more. This case is more than just a case about constitutional rights. This is a case about constitutional rights during a public health emergency. And there's a Supreme Court case decided back in 1905 that has a different way of looking at civil rights issues in the face of government's police powers, like the ability to make laws concerning public health. That was Jacobson v. Massachusetts. In that case, the state of Massachusetts passed a law requiring mandatory and free vaccinations for adults over the age of 21, up to the discretion of the local municipality. According to the law, anyone that was mandated to get the vaccine who refused was given a $5 fine, which is supposedly around $150 in today's currency. So what happened was, in 1902, there was a smallpox outbreak, and it was determined that all adults over 21 needed to get vaccinated so they could contain the outbreak. The plaintiff in that case, Jacobson, objected to it, saying that he had had a bad reaction to a vaccine as a kid. He was given the $5 fine, and he refused to pay it. Instead, he filed suit, arguing it violated his 14th Amendment rights. When the case got to the Supreme Court, they upheld the law, finding that in order to protect public health and safety, the scope of the state's police power includes the authority to enact reasonable regulations to do so. They also said that the Constitution secures liberty for every person within its jurisdiction, but does not give an absolute right for each person to be free from restraint at all times and in all circumstances. The court also said that in every well-ordered society charged with the duty of conserving the safety of its members, the rights of the individual in respect of his liberty may at times, under the pressure of great dangers, be subjected to such restraint to be enforced by reasonable regulations as the safety of the general public may demand. Whew, that was a long sentence. In other words, where there's an issue of urgent public safety, individual liberties can temporarily go out the window in the face of reasonable regulations enacted to resolve that emergency. The court also reasoned that because there was a real or substantial relation between the goal of protecting public health and the means they used in forcing vaccinations of all adults, they weren't about to strike down the law. Basically, the things to note about the Jacobson case are that 1, it stands for the general proposition that state and local governments can use their police powers to protect public health and safety. 2, in urgent situations, individual liberties can take a back seat in order to protect the common good. And 3, it predates a lot of civil liberty litigation. For example, this court opinion came out long before the women's liberation movement, the Civil Rights Act of 1964, and desegregation, World War II, and Supreme Court opinions allowing for people to be exempt from the draft on the basis of sincere religious objections to war. In fact, one point that the Jacobson court uses as support for its conclusion is the fact that men can be compelled to war even if their religious views on war conflict with military service. That's no longer the case. All of that together means that there are aspects of this opinion which are seriously outdated, and yet there are others which are in full use today, and the case has not been overturned to date. So now, in the year of 2020, we've seen unprecedented laws and emergency powers that some would argue are different than the 1902 smallpox outbreak. Some would also argue that the COVID pandemic is distinguishable from the smallpox outbreak in the Jacobson case because of the scope and duration of the pandemic and the responses by the government in trying to stamp it out. We've radically changed the way that we do business, and in a lot of cases, businesses have had to just stop doing business altogether. So then the question becomes, does an emergency like a pandemic warrant making an exception to our ordinary constitutional review, the 3-tiered system, meaning that because there's a public emergency, we give state and local legislatures the ability to create laws so long as they're generally related to resolving the emergency? If we say yes to that, we continue with Jacobson's reasoning. Or do we say, public health emergency be damned, the Constitution is the Constitution, and even in an emergency, those laws need to hold up to the 3-tiered scrutiny system. There has been a lot of litigation that's come out of the pandemic, and courts have not all agreed on what to do. Back in April, the Fifth Circuit determined that we should stick with Jacobson. As a result, they ruled that the state of Texas could prevent physicians from performing abortions because of the COVID-19 pandemic. The apparent intent of the law was to save medical resources like personal protective equipment or PPEs. That case is still ongoing. On the other hand, the United States District Court in Maine went the other way. In that case, the governor of Maine issued a number of emergency orders to slow the spread of the pandemic disease by requiring a 14-day quarantine and prohibiting campgrounds from opening to out-of-state visitors until those visitors had self-quarantined. The plaintiffs in that case filed suit alleging that the governor's emergency orders violate individuals' fundamental right to travel. The district court in Maine differed from the Fifth Circuit in that they rejected the Jacobson standard. In doing so, the court said that Jacobson represents a legal standard that is at least the opposite of strict judicial scrutiny. It barely authorizes judicial review at all. Instead, they said, in the 11 decades since Jacobson, the Supreme Court refined its approach for the review of state action that burdens constitutional rights. This evolution has likewise refined the scope of the constitutional right to travel. It then went on to say that, more or less, that when analyzing constitutional claims, we need to use the most recent case law, and that most recent case law tells us we need to use, in that case, strict scrutiny. So then the court went on to apply strict scrutiny. Remember that under strict scrutiny, in order for the law in question to be upheld, it has to be motivated by a compelling interest, and the law has to be the least restrictive way of meeting that interest. Here, the court found that protecting the public health in a pandemic like this is a compelling interest. Then the court said that because there's still so much unknown about the virus, they weren't persuaded that the measures taken to prevent the spread of the virus were not the least burdensome way of going about it. Because of that, the court denied the plaintiff's motion for a preliminary injunction. Setting aside the fact that the standard for preliminary injunctions is a little bit higher than what would be for a case on the merits in general for the most part, and also setting aside the fact that this case is ongoing at the appellate level, basically the point in talking about this case in this video is to point out that now different courts are applying different standards to these constitutional cases. And all of that is to say that the way that this field of constitutional law is populating itself is really interesting. And I think it's likely that we may see some of these cases make their way to the Supreme Court to give some clarity on this issue. Okay, setting that point aside, in this case, the Pennsylvania case, the judge talked about the Jacobson case and determined that in the time since Jacobson was decided, there has been substantial development of federal constitutional law in the area of civil liberties. And the court noted that in that time, courts have given greater deference to considerations of individual liberties as weighed against the exercise of state police powers. The court also pointed to the reasoning from the case that came out of the district court in Maine in rejecting Jacobson, as well as a number of dissents by United States Supreme Court justices in response to the Supreme Court's denials of emergency injunctive relief related to the pandemic. Ultimately, the court determined that it would not follow Jacobson and instead would apply regular constitutional scrutiny to the case. And by regular scrutiny, I mean the three-tiered scrutiny system which I described earlier in this video. One reason for this is because Jacobson is arguably best suited for a temporary, time-sensitive emergency. The pandemic, on the other hand, has lasted around 6 months, and based on the evidence on the record, it looks like the state doesn't anticipate there ever being an end date to the restrictions in Pennsylvania. The second reason that the court applied regular scrutiny is because they said it's necessary to maintain the independent judiciary's role as a guarantor of constitutional liberties, even in an emergency. Basically, the court said that while it can put less weight on the importance of individual liberties for a certain amount of time, the court also can't be overly deferential, because that would put the Constitution at risk. And according to the court, the government needs to respect the fact that the Constitution also exists in times of emergency. In support, he quotes the Supreme Court when it observed that the Constitution was adopted in a period of grave emergency. Its grants of power to the federal government and its limitations of the power of the states were determined in the light of emergency, and they were not altered by that emergency. In other words, the court here decided not to follow Jacobson and instead to use the more modern three-tiered scrutiny system to analyze the case. Okay, that's it for this video. To wrap it up a little bit, we went over a couple differences between state court and federal court, as well as binding authority and persuasive authority, but most centrally, we talked about the issue that's been growing over the last 6 months, that is the level of deference that should be given to state and local authorities during extended public health emergencies. Stay tuned for the next video where we'll go through how the court applied the three-tiered system in this case. Until then, what do you guys think? Do you agree with the courts giving more deference to state and local authorities in emergency cases like this, or do you think they should follow the three-tiered system like Judge Stickman did in this case? Let us know in the comments below. As always, I hope you found this informative and interesting, and if so, we would love it if you'd hit the like button. And if you're new to this channel and you want to see more, go ahead and hit the subscribe button and the notification bell so you can find out when the next video is uploaded. Thanks.